A, that the particulars of the candidate or supporters contained in the nomination paper are not as required by the Act of these regulations in respect of the elected post. That the nomination paper is not subscribed as required by these regulations in respect of that elected post. Having confirmed that the complainant is not a registered voter, the committee finds no reason to disturb the respondent's decision, which is rejecting the nomination papers presented by the complainant. If, however, the report had confirmed that the complainant is indeed a voter and the mistake is on the side of IPC, the committee would have directed that the error be rectified and the complainant allowed to withstand its nomination papers. The committee dealt with a similar issue in complaint number 72 of 2022 in bracket Robert Muneki versus returning officer Kikuyu constituency, where the investigations confirmed that the complainant had indeed registered as a voter and proceeded to direct the returning officer to consider his documents.
So, our final order in this particular matter, Council,
Yes.
in view of the foregoing, the committee finds that this complaint lacks merit, upholds the decision of the returning officer Bomachoge Borabu constituency, rejecting the nomination application by the complainant to run for member of National Assembly seat, Kisii County. The same is hereby dismissed with no orders as to costs. That's member of National Assembly, Bomachoge Borabu constituency in Kisii County. The same is hereby dismissed with no orders as to costs. You'll get a copy of this decision by 11 o'clock from here, together with proceedings.
Today?
Tomorrow. We've made quite a couple of corrections.
Fine.
Tomorrow by 11 p.m., yeah?
Most of that.
And we wish you well. The next two, yeah? Next matter, please.
DRC complaint number 63 of 2022. Stephen Owoko Oganga versus the chairman IBC.
Owoko, I thought I saw him somewhere here. Would you like to come this way? This is your matter. Owoko is a presidential aspirant who was running as an independent, and he's a man of great traveling and great reading, having been almost in all parts of Africa. And his philosophy is Owokoism, from the term Owoko, and he gave us a bit of that philosophy. So we will read this decision in light of the person that Mr. Owoko told us to be. So, summary of the complaint. The complainant is a presidential aspirant. He claims that he presented his papers at the Bomas of Kenya on 25th May 2022, but was denied entry, hence left the papers with the askaris at the gate. The relief sought. The complainant seeks to know the law the commission relied on to lock him out. The complainant also wrote a letter to the chairperson of the commission on 20th May 2022, seeking an extension of 30 days in order to comply with the requirement to collect signatures and photocopies of ID. So, analysis. It is the complainant's case that he applied to contest for the position of President of the Republic of Kenya as an independent candidate, having been cleared on 28 April 2022 by the ORPP as such. He stated that on 30th April 2022, he went to IEBC offices to have his details entered in the database, which was done. After that, he went to see Mr. Balang, the manager, DVREO, that is Director, Voter Registration and Electoral Operations, to collect the forms for collection of signatures of supporters. However, he was told that the IBC had drawn out of the forms due to the high number of independent candidates, and therefore he was advised to go back on Tuesday the following week. It was the complainant's testimony that when he went back on Tuesday, again he was informed that the forms were still not available, and he was advised to go back on Thursday. The complainant averred that the situation was not different on Thursday, and he was advised that he would be called once the forms are available. However, he was never called. He had to go back on 16th May 2022 when he was eventually given the forms. He explained that due to the short time that he had to collect the signatures, he requested for an extension of time to enable him collect the signatures. The respondent told the committee that once he received the forms, he dispatched the same to the counties immediately. However, considering the work involved in the collection of signatures, he was running out of time. He then wrote to the returning officer to extend time for him, and which request was granted on the 23rd of May 2022. He was given until 25th May 2022 when he was expected to return his papers for clearance. It was the complainant's testimony that on 25th May 2022, he arrived at the registration center, which was at Bomas of Kenya, at 9 p.m. to return his nomination papers. He avers that he had all the requirements with him. However, when he arrived, he found the gate was closed, but officers manning the gate refused to open the gate for him. He called Mr. Balang, who, after consulting, informed him that it is only the returning officer who could assist him. At this point, it was about 10 p.m. He stated that at this point he called his advocate, one Mr. Asembo, who drove to the place and was allowed to enter the registration center. However, when he came out after 45 minutes, that's when his advocate came out after 45 minutes, he confirmed that indeed the complainant could not be allowed in at that point. The complainant testified that at about 30 minutes to midnight, he was forced to leave his documents with the officers at the gate. He claims that he took photos and videos as he was leaving the document with the officers. The following day, the complainant wrote to IBC asking whether they had received his documents. He explained that he received a response to his letter from the returning officer informing him that the deadline was to be on 25th May 2022 at 5 p.m. informing him. It is important to note that one of the things the complainant wants the committee to do for him is to direct the IBC to give him back his documents. The complainant explained that according to him, the deadline was to be at midnight and not 5 p.m., which was never communicated to him. He just learnt of it on 27th May 2022. Mr. Kipkoge, counsel for the respondent, told the committee that the complainant is challenging the decision of the respondent of 27th May 2022. Counsel submitted that the complainant was filed hopelessly out of time and therefore the same should be dismissed. When asked by the committee whether he was aware when the committee was gazetted to start its sittings, counsel for the respondent replied that the complaint still should have been filed on time even though the committee had not been set up. Counsel submitted with regard to the complainant's list of supporters that the complainant did not meet the statutory timelines for submission of supporters. He pointed out that even after time was extended to enable the complainant collected the signatures, he still did not meet the timelines. Counsel referred the committee to the letter by the respondent extending the time for the complainant to submit his documents and submitted that the respondent specified that the deadline was 5 p.m. In conclusion, counsel submitted that the complainant did not meet the elementary requirements for being a candidate and therefore his complaint should be dismissed. When asked whether he communicated to the respondent that he would submit his papers at 9 p.m., the complainant answered in the negative. He explained that since the process of clearance by IBC before collection of signatures, they were working until midnight, he assumed that this was the case when returning the papers. The complainant stated that between the time he was cleared by ORPP and the time he was issued with the forms, he had lost 16 days, which he should have recovered through extension. On the issue of his lateness in filing the appeal, the complainant told the committee that he was not aware of the 48-hour requirement within which to file the complaint, and according to him, the committee was to begin its sittings on 9th June 2022. We now come to the decision of the committee. The matter came up for hearing on 18th June 2022. While the complainant appeared in person, the respondent was represented by counsel Mr. Kipkoge. It is important to note that during the complainant's testimony, counsel raised an objection to the effect that the complainant had not sworn an affidavit and was only relying on his witness statement. Consequently, counsel asked that the complainant be sworn in so that he gives his testimony under oath. The complainant was therefore took an oath as a Christian, after which his earlier statement was duly adopted as having been given under oath. Article 137 of the Constitution provides for the qualification of a person to be nominated as a presidential candidate as follows. There are 5, and I just read 1D. If the candidate is nominated by not fewer than 2,000 voters from each of a majority of the counters, and we have emphasized that. Regulation 39 of the General Regulations 2012 provides for the general requirements for independent candidates, and again we have set out Regulation 39 in extenso. The complainant appeared before the respondent on 25th May 2022 for clearance. However, the complainant requested for extension of time to allow him finalize the collection of signatures. In addition to the foregoing, the complainant was given an opportunity to reorganize his list of supporters and resubmit the same. He did not return to the registration center the same day. He only showed up the following day after the period of registration. The period for registration had lapsed. Regulation 2 of the General Regulations 2012 defines close of nominations to mean 4 o'clock in the afternoon of the last nomination day for respective elections. IEBC issued Gazette number 434 on 20th of January, in which the Commission prescribed at paragraph K that the days for nomination of political party candidates and independent candidates for the county governor elections shall be between Saturday 4th and Tuesday 7th June. I think that should be presidential elections. The nomination papers shall be delivered by candidates to the respective returning officers between the hours of 8 o'clock in the morning and 1 o'clock in the afternoon, and between the hours of 2 o'clock and 4 o'clock in the afternoon at a place designated by the Commission. The complainant told the committee that he was not aware of these timelines and that he thought the deadline was at midnight. This admission says a lot about a person who seeks to be the president of this country. He should have checked the timelines. Regulation 43.2 of the Election Regulations 2012 makes it a mandatory requirement that a returning officer shall hold a nomination paper invalid on any of the following grounds, and we focus on B, that the nomination paper is not subscribed as required by these regulations in respect of that elective post, that the nomination paper was presented after the prescribed period has lapsed. We have put our emphasis. The complainant admitted that he arrived at the registration center at 9 p.m., several hours after the time he was allocated to appear before the respondent, which was 5 p.m. In the High Court case of Edward Mukaya Kamala versus IBC, which is a 2017 decision, where an aspirant filed an appeal against the decision of this committee, the court recognized the centrality of timelines in the electoral process and the fact that a returning officer is justified to decline to clear an aspirant who presents themselves after expiry of the time specified. The court stated as follows, and we have stated out what the High Court said in the Edward Mukaya Kamala matter. And again, we have quoted the case of Protas Waswa Wafula versus IBC, also a 2017 matter, and we have stated out what the High Court found. In this case of Protas Waswa Wafula, the High Court went on to state that the judge says, I am persuaded that the disqualification was premised on valid grounds, premised on the constitutional and statutory provision and also the applicable regulations. I reiterate that it is incumbent upon persons seeking nominations to not only comply with the constitutional and statutory requirements, but also to adhere to set guidelines and regulations, including observing timeframes and submitting prescribed documents completed as required. When he appeared before this committee, the complainant did not even know where his documents were, having abandoned them at the entrance of the registration center. In the circumstance, even if the committee were to allow the complainant for whatever reason to submit his documents, what will he submit? Guided by the provisions of the law and the authorities cited above, we arrive at the conclusion that the complainant has not given compelling reasons why we should disturb the decision of the respondent, declining to clear him since he fell short of the mandatory requirements as provided for under the law. These then are our orders. In the premise, the committee finds and holds that the complaint lacks merit, and we hereby proceed to dismiss the same. The committee upholds the decision of the returning officer for presidential elections, rejecting the nomination application of the complainant to run for the position of the President of the Republic of Kenya. There shall be no orders as to costs. Mr. Owoko, you have lived a long life, and a long and interesting life, we must say. This should not be the last steps of your life. This could be an opening for many other things. And we commend you for the courage that you have taken to aspire for presidency, and also to show faith in the electoral process by coming before the committee to have your matter adjudicated upon. As you're well aware, you have a right to go to the High Court, and you get a copy of this decision and the proceedings, and should the High Court find otherwise, feel free to notify us. Okay? Yes.
Mimi kwanza nashukuru sana kwenyu. Leo asubuhi tulikuwa na breakfast with about 10 presidential independent, na tulikuwa tunawasengenya. Tunasema panel 1 ni watu ambao kwa kweli wamefanya kazi na moyo, na wana kinyongo, na ni watu wazuri.
Thank you.
Na nashukuru kwa ajili ya hiyo. Najua tunapotoka hapa nyinyi hamulali, tunafanya kazi nyingine nzito sana. Na kwa hii muda mfupi, najua mmefanya kazi, mmekosa usingizi. Mimi nasema tu nawapongeza.
Asante.
Mungu atie nguvu kwa hiyo kazi mnafanya. Nashukuru sana sana sana.
Asante.
Na nafurahi.
Asante.
Haki yenye nilikuwa natarajia kwamba haki imetendeka. Na hiyo ndio haki.
Kweli.
Nasema asanteni sana. Nasema naomba maji.
Mpe moja. Take one water.
Nikimeza hiyo matokeo.
Asante sana. Yeah. Na Mungu akubariki popote uendapo, wewe na familia yako.
Asante. Na ningekuwa rais, nilikuwa nimekuchagua wewe.
The very fastest. All right. Honorable Manzo, have you heard?
Yes.
Nyamu, have you heard? Thank you. Oginga, have you heard? From your mouth to God's ears. Okay. Asante sana. Let's go to the next matter.
DRC complaint number 87 of 2022. Juliet Muneki versus the chairman IBC.
This one also, so that we leave you there. Council?
In the matter, I'm Aguel for the complainant.
Aguel.
Aguel is A-G-W-E-L.
Yes. E-L, yes.
Oh, yes.
John Juliet Muneki, please stand. This very fashionable lady and very kind-hearted lady also stood as an independent, aspiring independent candidate for the presidency. And she's also very, very well traveled, and with over 26 years of experience in administration, public and private. And we got to know what she does and what drives her at great length. And apart from commending her sense of fashion, we said she's a brave woman. And she said every journey in life starts with the first step. And she has made that first step. And she's determined to go all the way. So it's in the context of that we are reading this decision of John Juliet Muneki, the person and the presidential aspirant. You can have a seat. Mr. Aguel. Aguel.
Oh, yes.
Yes, sorry about that. The committee noted the steadfastness with which you conducted these proceedings, and the dignified manner as a young advocate with which you conducted these proceedings, and we commend you for that. May God open your ways in many ways in practice.
Amen.
Okay? Good. The complainant is an aspirant for the position of the President of the Republic of Kenya as an independent candidate. She is a holder of the Bachelor of Science degree from Jomo Kenyatta University of Agriculture and Technology with over 26 years of experience in consultancy, employment, and business in public and private sectors. She aspires to implement socio-economic solutions, transparency, and accountability in leadership. By her complaint dated 7 June 2022, the complainant alleges that she was denied the right to a fair hearing by the respondent, and the respondent denied or failed to allocate her considerable time to provide missing documents despite allocating other aspirants 2 to 3 days to comply. She also alleges that she was discriminated against by the treatment she received when she went to submit her documents to the respondent, and that the respondent failed to acknowledge receipt of Form 13 by her running mate. The complainant prays that the respondent be allowed to be compelled to accept her supporters' signatures and copies of national identification cards from 25 counties to recognize from 32 duly filled with IEBC, and to further recognize the letter by the Commission for University Education dated 27th May as evidence of her educational qualification. In response to the complaint, the respondent filed a replying affidavit sworn by Mr. Moses Sunkuli, the acting director of voter registration and election operations (DVREO) of IEBC on 14th June 2022. In response thereto, the complainant then filed a response to the respondent's replying affidavit sworn on 16th June 2022. When the complaint came up for hearing on 19th June 2022 before the committee, the complainant was presented by Mr. Aguel Ochanda, advocate, whereas Mr. Moses Kikoge, advocate, appeared for the respondent. Counsel for the complainant admitted that the complainant submitted the list of her supporters' signatures but partially submitted copies of IDs of those supporters on 25th May 2022. Counsel further submitted that on 26th May 2022, the complainant submitted the remaining documents, but the same were rejected by the respondent, which prompted her to resubmit them to IEBC headquarters at Anniversary Towers, where the same were rejected again. That on 27th May 2022, the complainant's counsel submitted that the complainant received a call from IEBC requesting her to schedule a convenient date for nomination, whereupon she selected 3rd June 2022 at noon. When she appeared before the respondent, she admits that in this appearance, the copies of her supporters' IDs had not been duly stamped and serialized. She was therefore granted time between 2 p.m. and 4 p.m. the same day to rectify the irregularities to facilitate clearance as required by law. The complainant lamented that the time granted to rectify the irregularities by the serializing and stamping copies of supporters' IDs was too short, and she requested to do so in 2 days, a request she avers was declined by the returning officer. The complainant stated that the crux of her complaint is that the respondent exhibited discrimination, gender bias, and selective discretion compared to other aspirants who were granted between 2 and 3 days to hand in their nomination papers, whereas she was granted only 1 hour to comply. The complainant supported this assertion at paragraph 21 of her response to the respondent's replying affidavit, where she cites the following examples. Dorothy Kemunto, with the nomination of 2nd June 2022, was given up to 3rd of June in the afternoon to comply. David Mwaura Wahiga, with the nomination of 3rd June 2022, was given up to 2nd June 2022. We have lifted that as is in her complaint. 3rd June given up to 2nd June. Professor Luchiri Wajakoya, nomination date 30th of May 2022, was given up to 2nd June 2022. The complainant contends that due to the timeline given to her to comply, she was discriminated against and prejudiced. Upon probe by the committee, the complainant stated that she had no knowledge of the requirement of serialization of the documents and that IEBC failed to communicate adequately on that requirement. She, however, conceded that she attended the pre-nomination meeting for presidential aspirants briefing held on 18th May 2022 at Bomas of Kenya, where the aspirants were informed of all the requirements for presidential nominations. The complainant further conceded that although she had a few assisting staff in her entourage on the material day, she had a duration of 7 days, which was sufficient to comply with the requirement of serialization pagination had she been aware of that statutory requirement. The respondent abandoned the claim that the complaint lacked the requisite educational qualifications for the position of president. The respondent chose to focus on the question of discretion in extending time for compliance and Form 13 as the two issues that allegedly resulted in the rejection of the complainant's nomination papers. On 3rd June 2022, upon perusing the documents submitted by the complainant and upon validation of the list of supporters' IDs submitted by the complainant, the respondent noted that the complainant had only complied in 3 counties, Isiolo, Kilifi, and Kwale, out of the minimum requirement of at least 4 counties. The respondent then, on the complainant's request, allowed the complainant time between 2 and 4 p.m. to rectify the irregularities. The complainant, however, did not rectify the irregularities, and the respondent, pursuant to Regulation 43.3 of the Election General Regulations 2012, indicated on the complainant's Form 12 the reason for rejection of her nomination being insufficient identification documents for supporters, only 3 counties, Form 13 not duly filled by the deputy, and application invalid for lack of IDs. The respondent's counsel argued that it was not contested that the complainant had not complied with all the requirements at the time she presented her nomination papers on the 3rd of June 2022. In response to the allegation of discrimination and whimsical exercise of discretion, the respondent averred that the circumstances of each aspirant cited by the complainant differed, and that extension was granted on a case-by-case basis as circumstances required. The respondent further clarified that what was required of the complainant at the time was serialization/pagination, but not stamping. He maintained that stamping is not a requirement in law, but when the complainant was given time to rectify and submit the documents, she chose to stamp them instead of just serializing as directed by the respondent as required by law. This is our analysis. Per Gazette Notice number 430, dated the 20th of January 2022, the candidates intending to be nominated to contest for the presidential elections were required to present their nomination papers to their respective returning officer between Sunday the 29th of May 2022 and Monday 6th June 2022 between 8 a.m. and 1 p.m. and 2 p.m. and 4 p.m. respectively. From the testimony and evidence adduced during the hearing, it is not in dispute that the complainant attended the pre-nomination meeting for the presidential aspirants, where the aspirants were briefed on the requirements of documents to be presented during the presidential nominations. Further, it was uncontroverted that each presidential aspirant was handed a checklist for those requirements. The complainant thus cannot seek refuge in ignorance when all the information on the requirements had been handed to her in writing. Article 137(1)(d) of the Constitution on Qualifications and Disqualifications for Election as President provides as follows. A person qualifies for nomination as a presidential candidate if the person is nominated by not fewer than 2,000 voters from each of a majority of the counties. The provisions of Article 137(1)(d) is replicated in Section 23(1)(d) of the Elections Act and operationalized by the General Election Regulations 2012, the regulations. This follows then the decisions of the committee. The complainant presented the names, signatures, and identity card numbers pursuant to Article 137(1)(d), but upon validation, the same was found to be compliant in only 3 counties out of the required minimum of 24 counties. The complainant did not respond and address herself on this question during the hearing. In this regard, the committee makes a finding that there was non-compliance with this mandatory requirement of the Constitution and the law. Regulation 18 provides as follows, and we have set it out in extenso. It is this committee's finding that between 27th May 22, when she scheduled her nomination meeting with the respondent, and 3rd June 2022, when she appeared before the respondent, the complainant had at least 7 days to comply with the requirement to serialize the list of supporters' documents submitted pursuant to Regulation 18 of the Election 2012 regulations. Further, Regulation 18.3, highlighted here and above, is succinct that Form 13 should have been duly filled by her deputy presidential aspirant. The complainant herein did not present the statutory Form 13 together with the application for nomination on the nomination day of 3rd June 2022. By Regulation 43.2 of the regulation, the returning officer is empowered to hold an nomination paper invalid, and we have given out the grounds of invalidity. The complainant also alleged that the decision rendered by the respondent was discriminatory and it was exercised in abuse of discretion. This committee finds and holds that IEBC has discretion to prescribe the procedure to be followed in carrying out various exercises, including the process of registration hearing, even within statutory timelines. This committee is guided by Republic versus IEBC ex parte Peter Solomon Gishira, 2017, where that court relied on the case of KRA versus Meginya Salim Mugani, Civil Appeal number 108 of 2009, where the Court of Appeal delivered itself as follows. There is ample authority that decision-making bodies other than courts and bodies whose procedures are laid down by statute are masters of their own procedure, provided that they achieve the degree of fairness appropriate to their task. It is for them to decide how they will proceed. The complainant has not met the threshold set out in this case to establish the existence of abuse of discretion on part of the respondent. The committee finds that she was accorded sufficient time in law to comply, and that extending such time would conflict with the statutory timeline set out in Gazette number 430, as well as jeopardizing the opportunity of other presidential candidates to present their nomination papers on equal footing with the complainant. The committee therefore finds that the respondent exercised his discretion judiciously and that the complainant was given reasonable opportunity to comply with the registration requirements. These therefore are the orders of the committee. The committee finds and holds that the returning officer for the presidential election was justified in law to reject the complainant's nomination papers on 3rd June 2022 to run for the position of the President of the Republic of Kenya in light of the provisions of Article 137(1)(d) of the Constitution, Section 23(d) of the Elections Act, Regulation 18 and 42 and 43(2) A, B, C, and A, B, and D of the Election Regulations 2012. The committee therefore finds that the complaint herein lacks merit and is hereby dismissed with no orders as to costs. Juliet Muneki. Juliet, we again commend you for your courage. Let this not be a stumbling block to your ambition and desire. Keep moving. Okay? You will get a copy of the decision and proceedings by 11 a.m. tomorrow.
Okay, thank you.
Okay.
DRC complaint number 127 of 2022. Mike Sonko versus the returning officer, Mombasa County.
With the permission of my lawyer.
Yes. Just give a minute for them to settle. Yes, please, Council Jamu.
The permission of my lawyer senior, Dr. Hamino. May I take this opportunity to do the forum?
Yes, go ahead.
Alongside Dr. Hamino, Honorable Daniel Manzo, present. Mr. Bichile, present. Kennedy Onyanga,
Present.
Madam Eunice Tumalas,
Present.
Kevin Katisia,
Present.
Arnold Oginga,
Present.
and Cheruiyot Edward.
Present, Mr. Chairperson.
We do appear.
Sorry, I didn't get his name.
Mr. Edward Cheriot.
Edward Cheruiyot.
We do appear for the complainant in this matter.
Okay. And
My
yourself?
friend-
And yourself?
My name is Wilfred Young.
Okay.
I do also wish to introduce my learned friend, Mr. Mukele, who appears for the returning officer that is in this matter.
We had some interested parties. Was Wiper an interested party in this matter? Or it was just the two of you?
It was just, we are all representing the complainant.
The complainant?
And this is a matter where the ESCC is not an interested party.
No, it is not.
Yes.
Why should Okay.
You asked whether the interested party.
No, I thought Wiper was an interested party.
No,
No.
he was not.
All right.
We are
So,
ready for the judgment.
all right. This decision is lengthy. We propose to, due to the public interest contained in the matter, we propose to read it at length, and my colleague and Commissioner Justice Nyangaya will do the reading. I pray that we be patient and just listen to the judgment, whatever the outcome is. Okay? Commissioner Nyangaya?
Thank you very much, Mr. Chairman. Before I start to deliver this judgment, I would like to join my chairman in expressing our apology for keeping you waiting. It was never intended. We strive to treat everyone with utmost respect and dignity. And the summary of the complaint. The gist of the complaint by the complainant herein is that he was disqualified from contesting for the position of Governor, Mombasa County, on grounds of breach of Article 75 of the Constitution. According to the complainant, his disqualification was unfair since he was a pending appeal. He had a pending appeal before the Supreme Court, and therefore he should benefit from the saving grace provided for under Article 99(3) and 193(3) of the Constitution. The complainant prays that the committee determines that he was validly nominated. Our analysis of this. The complaint was heard on 16th June 2022. The complainant was represented at the hearing by advocates Dr. Kaminwa, Mr. Nyamu, Mr. Katisia, Mr. Cheriot, Mr. Bishire. The respondent, on the other hand, was represented by Mr. Mukele and Mr. Ndaiga, counsels. The complainant's case. Counsel for the complainant began the complainant's submissions by playing 3 sets of video clips. Counsel explained that the background of the first 2 clips was to show inter alia the production of documents by the complainant when he appeared before the respondent for clearance on 7th June 2022. According to counsel, the videos also sought to demonstrate that the documents were produced on time and that the fact of the issue of the active Supreme Court appeal by the complainant was brought to the attention of the respondent at the time. The respondent's counsel objected to the production of the 3rd video on account that the said video was not included in the agreed list for which the complainant had produced a certificate for production of electronic evidence. Thus, in limine, the committee expugns and shall not consider the said third video in making this determination. Counsel submitted that the complainant appeared before the respondent at 2 p.m. on 7th June 2022 and never left the place until 11 p.m. Counsel made submissions on two main grounds. Firstly, on the question of disqualification of the complainant for failure to submit his original degree certificate and a certified copy of the same, and secondly, on the issue of disqualification of the complainant on account of breach of Article 75 of the Constitution. Failure by the complainant to submit original and certified copy of the degree certificate. On the issue of degree certificate, it was counsel's submission that the complainant presented his degree certificate together with a copy of certified by his advocate. Counsel contended that it was not until 3:30 p.m. that the respondent brought to the attention of the complainant that he needed to present an original degree certificate together with a copy certified by the university. It was counsel's further contention that despite having received this information so late in the day, the complainant managed to bring the original certificate and a copy certified by the institution. Counsel claims that these documents were sent directly to the respondent on WhatsApp and eventually to her email at 4:48 p.m. Counsel made reference to the screenshots annexed to the complainant's supplementary affidavit. Counsel gave a narration of the process by which the complainant eventually got his degree certificate certified by Kenya Methodist University. Counsel stated that while the respondent indicated on the complainant's form that she had received the two documents at 4:42 p.m., she did not indicate at what time she disqualified the complainant for failure to submit the documents. Counsel concluded his submission by stating that even in 2017, IEBC cleared the complainant using a copy of degree certificate certified by his advocate, and therefore he does not understand why that is an issue this time round. According to the complainant, therefore, the requirement that his degree certificate must be certified by the institution was simply meant to create roadblocks for his clearance to vie in the 9th August 2022 elections. Mr. Nyamu, advocate, on his part submitted that there is no requirement in law that a degree certificate must be certified by the university that issued it. As such, the complainant was well within the law when he presented a copy of a degree certified by his advocates. Counsel argued that the respondent came up with a defeatist demand to block his client from contesting, that she changed the rules because it was not a requirement in law for one to present a copy of a certificate certified by the university. He therefore argued that since it was not a requirement of the law that a copy of the degree certificate should be certified by the university, the complainant should have been cleared, despite the certified degree certificate being submitted late. On this ground, it was submitted on behalf of the complainant that Article 75 of the Constitution forms part of Chapter 6 of the Constitution. As such, the focus is on Article 193 2G. Council highlighted the expression in accordance with any law, in quotes, within the provision to emphasize his argument that the two provisions speak the same language. To bring this into perspective, Council stated that Article 75 of the Constitution must be read together with Article 99.3 and 193.2G and 3 of the Constitution. With this in mind, Council submitted that the complainant brought to the attention of the respondent that he had an active appeal, but the respondent insisted that she needed to see evidence to prove that he indeed had an active appeal against his removal from office of governor, Nairobi County, through impeachment by the Senate. Council explained that they had supplied the respondent with a letter written by the complainant's advocate confirming that indeed there was an active appeal, which the respondent ignored. Council told the committee that the documents that were handed over to the respondent by the complainant on 7th June 2022 included a petition of appeal and the court's directions that the matter will be mentioned on 10th June 2022 before the Deputy Registrar for further directions. He asserted that these documents were presented to the respondent via a forwarding letter from his law firm. Council further explained that the following day, 8th June 2022, the Office of the Registrar of the Supreme Court of Kenya wrote a letter confirming that indeed there was an active appeal before the Supreme Court challenging the Court of Appeal's decision on the question of complainant's impeachment by the Senate. Council argued that once presented with the document, the respondent was duty-bound under Article 47 of the Constitution to take a step and investigate whether those documents were authentic. The respondent ought to have written to the Supreme Court to clarify the issues. She submitted further that Regulation 45(3) empowers the respondent to accept documents and seek clarifications. It was Council's further contention that under Article 249 of the Constitution, the respondent had the duty to ensure that she protected the sovereignty of the people, since that is what elections are about. On the issue of interpretation of Article 75 of the Constitution, Council submitted that Article 193(3) ought to be read together with Article 182 of the Constitution on eligibility and qualification of a candidate to vie for a gubernatorial seat. Council sought to bring to the fore the supervisory jurisdiction of the High Court under Article 165(2) of the Constitution, and argued that if the outcome of impeachment proceedings can be challenged at the High Court, or one can appeal to the High Court all the way to the Supreme Court if convicted, what is different with a governor who has been impeached benefiting from Article 193(3) of the Constitution? He contended that the respondent did not properly apply her mind to these constitutional imperatives, and as such erred in disqualifying the complainant. Council argued that Article 75 or any other article of the Constitution cannot be applied in isolation, that they must be applied holistically. Council referred to Article 259(1) of the Constitution, He argued that the respondent ought to have done anything possible to ensure that the complainant enjoys his fundamental rights, even if it meant giving him more time. He further argued that the complainant had all the required documents, only that the respondent demanded for more documents which were brought while the complainant was still seated at the respondent's desk. According to counsel, the respondent had 14 days to verify the documents, particularly the existence of the appeal. He further submitted that this committee has a duty to bring home the rights under Article 38 of the Constitution. Mr. Katisia, in his submissions, told the committee that the respondent was not fair in doing her job and that she was applying double standard. He made reference to Article 47(1) of the Constitution and placed emphasis on the word reasonable as used under that article. He also made reference to Article 24 of the Constitution, in which he argued that the respondent is an authority who is required to ensure the constitutional dictates of equality and equity are met. On the issue of double standards, counsel made reference to a Gazette notice dated 18th February 2021, in which the name of Governor Ferdinand Waititu appeared as a gubernatorial candidate in Kiambu County by election, and yet he had been impeached. It was counsel's contention that if Governor Waititu was cleared by IEBC despite his impeachment, why should they treat the complainant differently? Counsel stated that this fact was brought to the attention of the respondent. He pointed out that at the time he was cleared, Ferdinand Waititu had a case before the High Court challenging his impeachment, the same way the complainant has an appeal before the Supreme Court challenging his impeachment. Counsel further pointed out that IEBC is a party to the matter before the Supreme Court, and therefore the respondent should have been aware of the appeal. On his part, Dr. Haminwa referred the committee to Articles 259(3), Article 38(3), and Article 159(2), 193(3), and 21(1) of the Constitution. He argued that Article 75(3) of the Constitution is not applicable at all in this matter as a stand-alone provision. Mr. Mukele, counsel for the respondent, began his submissions by clarifying that Governor Ferdinand Waititu has not been cleared for purposes of the general election to be held on 9th August 2022. He argued that the documents presented by the complainant as a basis of alleging bias and discrimination only relate to a by-election in 2021 and not any other election. He explained that the Gazette notice referred to by the complainant's counsel was not a clearance, but an intent to participate in an election. According to counsel, this is procedural, and it is done before candidates are cleared. Counsel pointed out that even the complainant was gazetted as an aspirant ahead of the nomination process. On the issue of Article 38 and the complainant's political rights, counsel submitted that the respondent acted in full appreciation of rights under Article 38 of the Constitution and the laws that govern the conduct of elections, Council urged the committee to disregard the submission that the degree issue was brought to the attention of the respondent at 3:30 p.m. and that the respondent allowed the claimant to bring more documents the following day. It was Council's position that these issues do not appear in the complainant's affidavit and therefore amount to adducing of evidence from the bar. Council contended that there was no request by the complainant for extension of time to allow him present his documents later. Council summarized the reasons for the respondent's refusal to clear the complainant as failure to present original degree certificate, failure to comply with Article 75 of the Constitution, and failure to present certified copy of degree certificate from the relevant university. According to Council, the complaint as drawn only challenges the disqualification of the complainant under Article 75 of the Constitution. Council also played a video to demonstrate that the Supreme Court's appeal was brought to the attention of the respondent on the 8th June 2022, after the period of clearance had lapsed. He contended that this was an attempt to supply out of time documents that should have been presented on the 7th June 2022. According to regarding the claim made by the complainant that evidence of the existence of Supreme Court appeal was presented to the respondent in form of a letter from the complainant's advocate, Counsel for the respondent that the said letter was received at 4:31 p.m. Additionally, Counsel argued that the letter referred to by the complainant's counsel only referred to existence of an appeal without any proof. Counsel argued that in addition to the issues concerning Article 75, the disqualification of the complainant was also due to failure to submit documents on time in contravention of the set timelines. Counsel also revisited the first video played by the complainant's counsel and argued that the video does not show any of the documents that the complainant claimed it showed, and therefore the contents are irrelevant. On the issue of interpretation of Article 75 and Article 193(3) of the Constitution, Counsel submitted that the issues before the committee are not related to Article 193(3). He referred the committee to Section 22 of the Elections Act and Section 13 of the Leadership and Integrity Act. Counsel maintained that Article 75 and 193(1) cannot be read together with Article 193(2) and 3 because Article 193(1) is a self-executing and self-governing provision. Counsel sought to distinguish between eligibility and qualification as used in Article 75 and disqualification as used under Article 193(2)(g) of the Constitution, and submitted that eligibility in its operation is very wide in scope. He urged the committee to look at Article 193 in relation to Articles 10 and 2591(d) of the Constitution. Counsel made reference to Article 181 1 of the Constitution 2010 that spells out the grounds of impeachment. He also made reference to Gazette Notice number 10904, published published on 18th December 2020, and argued that some of the grounds listed in the grounds of impeachment of the complainant including crimes under national laws, which according to him do not fall under Article 193(2)(g), but which falls squarely under Article 181 of the Constitution 2010. Council held the position that there cannot be a review or appeal for impeachment under Article 193 of the Constitution. On documentation, Council referred to paragraph 7 of the respondent's replying affidavit to the effect that certain documents must be presented to the respondent before an aspirant is cleared to contest. He argued that there has to be a demonstration that there is an active appeal, which was not done. The respondent told the committee that she disqualified the complainant on 3 grounds: that he did not present an original degree certificate, a copy of the degree certificate was not certified by the university, and for non-compliance with Article 75 of the Constitution 2010. She explained that the complainant arrived at the registration center at 2:30 p.m. and that after going through the scrutinizing his documents, she disqualified him a few minutes to 4 p.m. He, however, stayed at the registration center after he was disqualified. In conclusion, Council submitted that whereas it is true that indeed the Commission plays a facilitative role in the electoral process, this must be done within the law. In rejoinder, Council for the complainant argued that the complainant was disqualified before his documents were received, that the documents were received at 4:42 p.m. It was Council's contention that if the complainant had appeared before the respondent on 6 June 2022, he will have had an opportunity to present his papers the following day. He explained that the complainant was before the High Court on 6 June 2022 and that he did not pick the said date of 7th June 2022, that the complainant complied with every requirement but was disqualified on the basis of Article 75. It was Council's contention that the findings of breach of Article 75 of the Constitution was made by the Senate, and that this is why it is important to look at Article 193(2)(g with the emphasis on the words, it quotes, has been found, close quote. He also submitted that Article 193(3) is applicable since the issue before the committee is an issue of eligibility. Council maintained that Article 75 of the Constitution cannot be read in isolation. It has to be read together with Article 193 of the Constitution. Council explained that for one to be elected, the person must be eligible and qualified. This takes us to Article 181 as read with Article 193 of the Constitution. In this regard, Council submitted that the respondent cannot expand reasons for disqualification. He urged the committee to be alive to its obligations under Articles 249, 259, 21, and 38 of the Constitution. He explained that the committee has the duty to promote, protect, and advance the provisions of the Constitution. He asked that the committee should give these provisions life even where there is none. And this is our decision, the committee's decision. Having listened to all the parties and considered the pleading filed in this matter, the committee makes its determination as follows. To consider the question of whether the decision of the respondent in rejecting the complainant's nomination papers was proper, it must be borne in mind that the respondent rejected the complainant's nomination papers on the following grounds. 1. Failure to present an original degree certificate. B. Failure to present a certified copy of degree certificate. And C. Breach of Article 75 of the Constitution of Kenya. The committee appreciates that Section 22(1)(b) of the Elections Act 2012 provides that to be eligible for election, one must have a degree from a recognized university. We understand this to mean the respondent was required to ascertain the educational qualifications of an aspirant in compliance with Section 22 above. In this regard, Regulation 47 of Elections General Regulation 2012 provides that a certified copy of the certificate evidencing educational qualification shall be submitted to the respondent. The certification that was being accepted by IEBC Oh yes, thank you. Let me take that again. The certification that is being accepted by IEBC for 2022 general election is certification by the university issuing the certificate. To the Commission, only the issuing authority can authenticate a document it has issued. And that is the reason why certification by an advocate is not allowed in this election, in the present election cycle. Additionally, it was admitted that the complainant did not present an original degree certificate. The committee notes that the requirement of an original degree was applied to all candidates across the board whose part of qualification required a degree qualification. The respondent was therefore justified to insist that the complainant presents his original degree certificate before he could be cleared. In the case of Hezekiah Oira versus Patrick Kwako, 2017, the court stated in reference to the requirement of a certified copy of a document as follows. The law provides that public documents should be produced by the makers, in which case the person producing the same should have the copies properly certified and or sealed. This is the law as per Section 80 of the Evidence Act, which provides that 1. Every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees therefor, together with the certificate certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of seal, and such copies so certified shall be called certified copies. It may be true that in 2017 the complainant was cleared using copies of his degree certificate certified by his advocate. That does not take away the requirement that for purposes of the 2022 elections, the Commission require the same to be certified by the issuing institution. It is important to note that the requirement that a degree certificate be certified by the issuing institution was a requirement for all candidates, not only the complainant. To this end, we note that nothing has been placed before this commission to show that other than the complainant, every other aspirant of equal rank was not required to have their degree certificate certified by the issuing university in order to found a claim for discrimination. The committee notes that the complainant has admitted that this certified copy was presented to the respondent after 4 p.m. This is the same position of the respondent who produced a confirmation that she did indeed receive the original certificate and a duly certified copy at 4:42 p.m. Thus, it is clear that these particular documents were late. However, we understand the complainant to be saying that this should not bar his clearance, as he himself was within the registration center before 4 p.m. Counsel for the complainant argued that since
54,
Oh, yes.
55,
Oh, yes.
56.
Yeah,
Go straight to 57.
Oh, yes. In DRC complaint number 236 of 202, Anthony Mutembe Julius versus returning officer Egembe South constituency, where the complainant claimed that he arrived at the registration center, but his banker's check, which he didn't have at the time, he presented himself before the respondent was delivered to him while he was still at the registration center, and according to that complainant, it was his banker's check that was late, and not himself, since he was still at the registration center on time. The committee, in dismissing the complainant, observed as follows. The committee finds and holds that the responsibility of obtaining the banker's check as well as the list of supporters was within the purview of the complainant, and his failure to present the said check and list of supporters within the prescribed time was his own. His omission could have been avoided had he prepared adequately for the nomination process. Counsel further argued that if the complainant had presented his documents on 6th June 2022 and there was a problem, he could still have had a chance to bring the documents the following day on 7th June 2022. Granted, if the complainant had appeared before the respondent a day or so before the deadline, he would have had an opportunity to resubmit his documents. To the committee, it is clear that by the time the complainant presented his degree certificate duly certified by the university, he had already been disqualified. Regulation 2 of the Elections General Regulations 2012 defines close of nomination to mean 4 o'clock in the afternoon of the last nomination day for respective election. The IEBC issued a Gazette Notice number 434 on 20th January 2022, in which the Commission prescribed at paragraph K that the last day for the nomination of county governor election was Tuesday, 7th June 2022 at 4 p.m. In Edward Mukaya Kamala, Independent Electoral and versus Independent Electoral and Boundaries Commission 2017, where an aspirant filed an appeal against the decision of this committee, the court recognized the centrality of timelines in electoral processes and the fact that a returning officer is justified to decline to clear an aspirant who presents themselves after the expiry of the time specified. The court stated as follows, and we have included the quotation in the judgment, and that can be read. The Supreme Court in petition number 3, 4, and 5, Raila Odinga and 5 others versus IEBC and 3 others 2013, while addressing itself on the question of adhering to timelines set under the Constitution and the law stated in its ruling delivered on 26 March 2013 on page 7 of 10 thereof as follows. The parties have a duty to ensure they comply with their respective timelines, and the court must adhere to its own. There must be a fair and level playing field so that no party or the court loses the time that she is entitled to, and no extra burden should be imposed on any party or the court as a result of omissions or inadvertences which were foreseeable or could have been avoided. We therefore find that the requirements under Section 22 of Elections Act as read together with Regulation 47 are standards set by the law, and the complainant was to ensure compliance with the same. We do not agree with the submissions by counsel for the complainant that the respondent needed to do follow-up to confirm authenticity of the documents presented to her by the complainant. We adopt our reasoning in DRC complaint number 239 of 2022, Jeremiah Kiwoi versus Graham Samboja and others, on the fact that IEBC does not have investigative powers and only relies on the documents produced before it for consideration in making its decision. To the committee, the respondent cannot be faulted for her decision on the first two grounds. The third ground for disqualification is indicated in Form 17 as breach of Article 75 of the Constitution. During the hearing, counsel for the respondent submitted on this ground that the complainant was impeached by the Senate of the Republic of Kenya, as confirmed in Gazette Notice number 10904 of 18th December 2020, which the respondent relied on in disqualifying the complainant. Counsel submitted that in the circumstances, the complainant is disqualified under Article 75 from holding any public office. However, on their part, counsel for the complainant asked the committee to find that since the complainant has an active appeal before the Supreme Court challenging the decision of the Court of Appeal regarding his impeachment, the complainant should benefit from the provisions of Article 193(3) of the Constitution. This committee was invited to give an interpretation of Article 75 and 193 of the Constitution cited above and the interplay between the two provisions. The parties particularly asked the committee to make a finding as to whether or not the complainant can benefit from the provision of Article 193.3 on the basis of his pending appeal before the Supreme Court. The committee notes that there is a letter from Registrar of the Kenya Supreme Court, the Supreme Court of Kenya, dated 8th June 2022, which has been admitted was served on the respondent on the said 8th June 2022. As we stated in the Samboja case, Supra, that we, under quote, agree that it is part of the Commission's mandate to consider the documents produced before it during nomination and make a decision on the basis of those documents as to the qualification of an aspirant. In the present complaint, it can be seen from the referred letter of 8th June 2022 that indeed there is an appeal. However, there is an appeal, pending at the Supreme Court of Kenya. This letter was not produced before the respondent on 7th June 2022 by 4 p.m. for the same to be considered in the clearance process of the complaint. We disagree with the complainant's submission that once presented with the document, the respondent was duty-bound under Article 47 of the Constitution to take a step and investigate whether those documents were authentic. In the case of Ethics and Anti-Corruption Commission versus Granton Graham Samboja and another, Kenyatta University and another, interested parties, 2021, petition 389 of 2017, in which the integrity and educational qualification of first respondent governor Granton Samboja was in question. The High Court stated on the question of IEBC to conduct investigations on documents presented to it as follows. The second respondent, IEBC, mandate is specifically enshrined in the Constitution under Article 88 of the Constitution 2010, which includes the conducting or supervising referenda and elections to any elective body or office established by the Constitution or other laws. The Constitution mandate of the IBC, it appears, does not include authenticating academic certificates. It therefore follows the second respondent, IBC, lacks power to investigate and or determine the validity or otherwise of the certificates presented by the intending candidates, as long as on the face of it the candidate presents a prima facie valid document. Therefore, we do not find fault in the respondent's decision on 7th June 2022. The consideration by the committee of and or the interaction between Article 75 and 193 of the Constitution 2010 is unnecessary. The court in Samboja Supra went on the state in conclusion that, and I quote, the Commission's mandate does not extend to undertaking inquiries into the validity and legitimacy of academic certificates and credentials supplied to it by various candidates, but merely acts in trust on the face value of the documents, and that the impeachment of integrity of an aspirant must be on account of an order of the court or quasi-judicial body. The committee relies on the above case and finds that the respondent was under no obligation at all to to investigate the documents presented before her. The burden of confirming and proving the existence of documents and facts that they needed to rely on for clearance was squarely on the complainant. We have taken note of the fact that the Samboja case above was not decided on merit since the court found itself without jurisdiction. However, we remain convinced that the conclusions made by the court on this issue are at the very least persuasive, if not binding, on this committee. Before we leave the issue of Article 75 of the Constitution, we think it is important to address an issue that came up during the hearing, where the complainant accused the respondent of having treated him unfairly and with bias. To justify his position, counsel for the complainant pointed out to the committee that Governor Ferdinand Waititu was cleared to run for the gubernatorial seat in Kiambu County after his impeachment as the governor of the same county. According to counsel, during that time, Honorable Waititu's case challenging his impeachment was still pending in court. This position was opposed by the respondent's advocate, who stated that the said Ferdinand Waititu was not clear to run. Rather, the Gazette notice referred to by counsel is not a clearance but an intent to participate in an election. This position was not controverted, and we see no reason to go further. Finally, we rely on the word of the High Court in Protas Waswa Wafula versus Independent Electoral and Boundaries Commission. The court stated as follows: any person seeking clearance, either as a party member or as an independent candidate, must satisfy as of necessity all the requisite constitutional and statutory requirements. He must also satisfy the provisions in the applicable regulations. This is because the electoral process is grounded on the Constitution and the law and regulations enacted to give effect to the said process. Such regulations aim at ensuring a smooth and credible process. Non-compliance with any of the requirements leads to disqualification. Accordingly, it is incumbent upon persons seeking nomination to familiarize themselves with all the constitutional and statutory requirements and also the applicable regulations governing the process to avoid inevitable rejection of their nomination papers. The court notes further that I am persuaded that the disqualification was premised on valid grounds, premised on the constitutional and statutory provision, and also the applicable regulations. I reiterate that it is incumbent upon persons seeking nomination to not only comply with the constitutional and statutory requirements, but also to adhere to the set guidelines and regulations, including observing time frames and submitting the prescribed documents completed as required. Guided by the provisions of the law and the authorities cited above, we arrive at the conclusion that the complainant has not given compelling reasons why we should disturb the decision of the respondent declining to clear him, since he fell short of the mandatory requirements as provided for under the law. Okay.
So, in relation to this particular complaint, in the premise, the committee finds and holds as follows: that the complaint lacks merit and is hereby dismissed. The committee upholds the decision of the returning officer, Mombasa County, rejecting the nomination application by the complainant to run for the position of Governor, Mombasa County. There shall be no orders as to costs.
Much obliged, we are grateful for the patience in listening to us. And maybe they are fixed mind as our plan is an political persecution, even in the hand of this tribunal. Extended from the chairman himself, and we expect more justice in this particular committee. And for that matter, we do request that immediately you be given a copy of the judgment so that we may proceed to the High Court, as you have made for us very salient grounds for appeal.
Okay.
From the decision that we made.
Okay.
It's a pity that this country is actually placed in the hands of a system that is so polluted.
Okay, Mr. Nyamu, we have heard you. We will. There are quite a number of corrections to be made in the judgment.
Your Honor, we need that judgment like in minutes. Because tomorrow we are not taking any chances. Tomorrow we'll find ourselves appearing before the High Court another day. And we are told that we are late.
Okay.
So this is a matter that actually before the end of the week, this judgment leaked long time ago. I saw it at 5 in the morning. That's when I learned that our petition, our complaint had been dismissed. So basically, let's have it.
Okay. Salome, how soon can we make the corrections? So you want the proceedings? No, just a moment. Dr. Kamino, just a moment. How soon can we have the judgment? I'm asking from our secretariat. Okay, Mr. Nyamu, I am told that these corrections will take probably an hour to make. So let's say before the close, is it possible for you to start doing it now so that as we read the next one, we can be able to have a fair draft?
And we also need the
proceedings, transcription, how long will it take? Like how long? You can see this gentleman drill, 2 hours.
We'll wait.
You will wait? Okay. And then Salome, you can be able to certify them, isn't it? So let's say everything should be done by midnight. But in the meantime, you start so that we can read the following judgment as you are doing that. Okay? All right.
Honorable Chair.
Yes.
We'll also be able to be praying for the audio to be supplied with the audio so that we can check.
The audio requires
We can supply them with a flash disk.
The audio, sometimes they have to do some editing, or what is the process? It is them. We've contacted a professional firm. They know what to put. Can we give them the raw audio? Just a moment. Just a moment.
Raw audio.
Just a moment. You want raw audio?
Yes.
Okay. Is it possible?
It's up to you to decide if you want to give it up.
Okay. Okay, let's read the following one while the commissioners consider that request.
Your Honor, we urge you to consider it. Very serious.
It is the commissioners to
The rights of the people of Mombasa are on trial.
No, we agree.
The commission wants to elect somebody from Mombasa.
We agree. We agree. We agree. We agree. We said let us be civil. Why don't we listen to the next matter and see if the reactions will still be the same? Yes, let Dr. Kamino say something. Yes, Dr. Kamino.
Yeah, well, may I say with tremendous respect, I'm very much shocked by the outcome. It is not easy to believe that your committee can come up with such a decision. May I say to you with tremendous respect, Sonko is not a Kenyan. Some of us are here because we are concerned about the posterity of this country. not about Sonko. Sonko, there will be a time when there will be no Sonko in Kenya. The ruling you have just delivered really is in conflict with the constitution you have. If you read the constitution, you will see that it emphasizes that at some stage one should get a feel that it is a law system.
Isn't that the reason why the High Court is there, Dr. Kaminwa, so that you can go there and have those things discussed?
We do not have to go to the High Court.
We believe.
With respect, when we have a lawyer, we are standing presiding over this case. We are appalled by your outcome.
Thank you, Dr. Kaminwa.
We are appalled.
Thank you.
It's not something we expected from you at all.
Thank you, Dr. Kaminwa. Let us call the next matter. As I told you, I play a facilitative role in this committee. The decision is made by commissioners and not by me. Please, let's have the next matter. Let's just continue being civil.
Your Honor, with respect, I was even canvassing to see whether you can be made a judge of Court of Appeal.
But now that has changed.
Yeah,
Okay. What if the decision was otherwise, Dr. Kaminwa? Give us the next decision.
May I mention one matter?
No, just let's have the next.
I have a matter here, Your Honor, which I would like to mention. I want to go to bed now.
Yes.
Yeah. There is a case you are withdrawing. A civil suit number 137 of 2022. 137 of 2022. And my learned friend, Noreen, has got something to say.
Which one is that? Do we have it?
137 of 2022.
No, we'll do that after this, Dr. Kaminwa. We have a set. Okay.
Please, I want to go and sleep.
Okay, Dr. Kaminwa. I'm sorry.
Your Honor, I'm suggesting that instead of reading the one for wiper, instead of reading it wholly, and we've agreed. Because we know it says that wiper be given an opportunity to present another candidate. Just give us a judgment. We go and deal with it. We don't waste time reading the one.
You see, Dr. Nyamu.
That is what it says.
Thank you for knowing it in advance. Nyamu, these are our proceedings. Please respect our proceedings. Tomorrow is also there. This is our proceeding. We will do it according to what we want. Okay. All right.